Hi everyone, this is Jeremy from Legal Studies Advantage. In this Success Tips video, we will discuss the topic of succeeding on law school essay exams. Succeeding on law school essay exams involves two key components. First, you must know the law. This will actually help you to identify the issues, which are factual scenarios that may satisfy the elements of different legal definitions, and which could result in some legal action being taken. Second, you must know how to write essay exam answers in a clear, organized way. Usually exam answers can be organized with a common legal writing tool called IRAC. That's spelled I.R.A.C. IRAC is an acronym that stands for Issue, Rule, Analysis, and Conclusion. Actually, the A in IRAC may sometimes also mean arguments or application. In any case, whether it's analysis, arguments, or application, all of these words refer to the same thing. Let's explain how to use each part in writing your exam answers. On a classic essay exam, you will be given a fact pattern. Note that courts often use something similar to IRAC as the pattern for writing their opinions. On a side note, recall that a court opinion in legal jargon is not just what the court thinks should happen, but rather is the record of the binding legal outcome decided by the court. Okay, back to our subject. One key difference between an opinion and an essay exam is that in a court case, the court will usually provide a summary of the story, or the facts, of the case. You will not have to do that on your essay exams because the facts will already be stated for you in the exam question prompt called the fact pattern. Your job will be to write out each of the components of IRAC. Remember that your law school professor will have many essay answers to grade, so anything you can do to make grading easier is a good idea. You may decide to actually write out the words issue, rule, analysis, and conclusion as headings for your answers in order to orient your professor to the organization of your answer. As another important note, be sure that you pay close attention to what your professor is actually asking for on your exam. You want to be sure that you actually end up answering the exact question that was presented within the fact pattern and question prompt. It may say something like, identify the claims, laws, arguments, and defenses that the parties in the fact pattern could raise and determine what the court would conclude. Okay, on to the various components of IRAC. First, let's start with I, issue. The first thing you must do on the answer to your essay exams is to state the issue. This is where you identify potential causes of action that parties could bring. These are legal questions the court would have to try to answer. For example, the question might be, was defendant negligent? If so, there is a legitimate cause of action. Think about that term for a moment, cause of action. This is the thing that can cause a court to take action against someone, such as a defendant. So, looking at our example, if defendant was negligent, defendant will probably be required by the court to pay plaintiff for plaintiff's injuries. The plaintiff's cause of action is negligence. That is what might cause the court to act to compel the defendant to pay. The question or issue before the court is, quote, whether defendant was negligent. Sometimes it is better to state the cause of action or the issue as a statement beginning with the word whether instead of as a question. Note that if the defendant is shown to be negligent, the defendant may have to pay the plaintiff unless the defendant can show some sort of defense or excuse against the court enforcing payment. Okay. There's a lot going on here, but the reality is that all that you probably need to write on your exam is issue, whether defendant was negligent, period. Let's move on to the next part of IRAC, state the rule. This second part, stating the rule, is where you will write down all the statements of law that apply to the issues raised by the fact pattern. A rule is composed of various elements. Elements are the requirements that must be satisfied in order to meet the full legal definition for that cause of action. For example, a rule may be stated, quote, negligence exists where there is a breach of a duty of care that causes some damage to another person, end quote. Or, instead, you might write, quote, the elements of negligence are duty, breach, causation, and damages, end quote. The next part of IRAC is to state your analysis. Again, as with issue and rule, you may want to begin with the word analysis, and then begin your analysis discussion. In the analysis section, you will write out the arguments that both sides might raise. So what do you write? Well, you identify a what and a why. You identify what facts satisfy a particular element of your rule of the cause of action being brought by the plaintiff, and why you think it is satisfied. It can help to think of key phrases that can help you to formulate your analysis. The following form may be a helpful way for you to phrase your analysis. Quote, on one hand, plaintiff will argue the element, and then fill in the element, is satisfied because, and then refer to some of the facts in the fact pattern. But, on the other hand, the defendant will argue that that same element is not satisfied because, and then you'll insert some more of the facts from the fact pattern. Let's give a more concrete example. For example, you may say, quote, quote, on one hand, plaintiff will argue that the element of damage was satisfied because plaintiff broke her leg and had to pay for a lot of medical expenses. On the other hand, defendant will argue that while plaintiff was harmed, plaintiff's broken leg was not caused by the defendant because, and here you will insert various facts that support the defendant's argument. Usually professors try to develop very arguable fact patterns with lots of facts that you can point to, lots of things that happened in the story of the case that can be used by either party to argue for or against a cause of action, the application of a defense, remedies, and so forth. Identifying reasons, or in other words, arguments, why certain facts satisfy the elements of the rule is called applying the facts to the law, or arguing the facts. Arguments should be made for each element from the perspective of each party. That is the essence of the analysis section, and may be the most important part of I.R.A.C on your essay exam answers. Note that you may also want to include the defendant's possible defenses in the analysis section. For example, defendant may argue that there is a defense against the cause of action because of, and then you would raise the various elements of the defense and essentially do a mini I.R.A.C analysis for the defense. It's important to note that if the question assumes that certain elements are already satisfied, then the issue could be stated a little bit differently. For example, the fact pattern or question prompts may say, quote, for this question, assume that the defendant had a duty to be careful, a duty of care, and that the defendant breached that duty, end quote. In that case, the issue might be stated, quote, whether there was causation and damages resulting in the defendant's liability for negligence, end quote. Alternatively, the issue might still be stated as, quote, whether defendant was negligent, end quote. But in the analysis in the second example, you might note that, quote, the elements of the duty and breach were already established or given in the facts, so they are not argued here, and the only issues left to address are whether there was causation by the defendant and damage to the plaintiff, end quote. Finally, let's move on to the conclusion section. So we've already stated our issue, we've already stated our rule, we've already provided an analysis that shows the arguments each party might make for each particular issue. Finally, you would write the word conclusion, and then write the conclusion statement. Please understand that the best essay questions are often ambiguous. They don't usually have a right or wrong answer. Although distinct from many classes you may have taken in your undergrad, law school exams are not necessarily testing identification of proper conclusions, but rather are primarily testing your ability to make well-rounded analysis and arguments. By well-rounded, I mean making arguments on both sides of the issue, of whether or not elements are satisfied, and whether or not a definition of law, or in other words, a rule, has been met. The reality is that what conclusion you reach is often not very important. The conclusion may take a form such as, quote, the court is likely to conclude that defendant was negligent, end quote. It's important, though, that the conclusion answer the whether question stated in the 1 or 2 sentence issue statement that you made earlier in your I.R.A.C. Points may be awarded by your professor for including each part of I.R.A.C. for identification of an issue or cause of action the plaintiff could bring, for a correct statement of the law, for the soundness of logic and arguments made on both sides of the issue in the analysis and reasoning section, and for simply stating some conclusion. Now, just to reiterate, the quote-unquote right answer on a law school exam probably is not a certain conclusion, but rather is an essay that shows knowledge of law along with good reasoning and organization. This makes sense because the law really doesn't produce definitive outcomes, but rather is very arguable as to what outcome it reaches. So don't try to be too definitive in how you state your conclusions. Just like in a real court case, there are often good arguments on both sides of an issue, and a court may decide either way for the plaintiff or for the defendant for any number of good reasons. Outcomes in the legal world are pretty arguable, so in your conclusion, try to use words like usually, or probably, or likely. For example, you may say, the court is likely to conclude that defendant was negligent and that defendant probably will be required to pay damages. In a real case, if the elements of a cause of action are shown, the court will take action and issue orders to remedy harms done. Civil liability may be imposed, financial judgments may be ordered, or other actions may be compelled. In a criminal case, a punishment may be imposed. In a constitutional law case, some government action may be determined to be unconstitutional, etc. On your exams, you may be expected to provide examples of the types of remedies a court might order based on the fact pattern you are given. Prior to exams, it may be a good idea to ask your professor what their expectation is regarding discussing damages on your final exam. So, in summary, you may want to write a heading for each section of I.R.A.C on your essay answer. These headings would be issue, rule, analysis, and conclusion, just to make sure that the grading and visual cues in your essay answer are easy for your professor. It certainly can't hurt your grade. Then, you'll write something like the following keywords in your IRAC answer. Quote, the issue is, and then you state the issue. Quote, the rule is, and then you state the rule. Then, when you get to the analysis section, you will argue both sides by saying, quote, on one hand, plaintiff will argue that XYZ element is satisfied because of some fact from the fact pattern. But, on the other hand, the defendant will argue that XYZ element is not satisfied because of some fact from the fact pattern. End quote. Basically, one party will say that these facts satisfy these elements, and the other party will say that these other facts don't satisfy those elements, and so on. The last thing you will write is a simple conclusion statement such as, quote, the court is likely to conclude that. Then, you just pick something to conclude. While it is essential to argue both sides of an issue, the conclusion you finally reach really is not that important, as long as it answers the issue question. If the issue was whether the defendant was negligent, the conclusion needs to probably either be, the court will probably conclude that the defendant was negligent, or the conclusion will be, the court will probably conclude that the defendant was not negligent. Let me now just point out a few additional items of note. First, note that your essay answers should be written as though you were a third-party narrator, commentating on what each party will argue and on what the court is likely to answer and conclude. Don't write like you are the court. Don't write like you are one party's attorney, but argue what each of them will say and do. Next, note that you should include one brief IRAC for each issue in a fact pattern. There may be several causes of action that might be raised by a single given fact pattern. Spend most of the time in your essays on the biggest issues. One helpful way to organize your essay exam answer is as a series of individual IRACs, with one IRAC for each cause of action, and any possible defenses to those causes of action being discussed in the analysis section of your IRAC. Finally, it is also noteworthy that sometimes law professors provide you with parties whose names suggest their potential roles in a case. Take the example of two people in a fact pattern, Paula and Dave. Sometimes professors do this to help you identify that Paula is likely to be the party who is harmed, and who is bringing this suit based upon a cause of action to try to sue Dave. In other words, Paula would be the plaintiff, and Dave would be the defendant. P for Paula, P for plaintiff, D for Dave, D for defendant. Note that, just like in real life, it is possible a fact pattern could suggest that the defendant may also have some sort of cause of action against the plaintiff, where Dave could bring a suit or a claim against Paula, and where Dave could then be acting in the role of plaintiff, and where Paula would then be acting in the role of defendant. As another example, in a property law situation, the parties might be Larry and Tina, where Larry is a landlord and Tina is a tenant. Sometimes law professors seem to like to help orient test takers with role hints built into the names of the parties themselves. That's just something to be aware of. Note also in that last example, between Larry and Tina, where if Larry was the landlord and Tina was the tenant, it's possible that either one of those individuals could end up being the one bringing a cause of action against the other. Perhaps Larry has wronged Tina, and Tina would then be the plaintiff suing Larry. Or perhaps Tina has wronged Larry, in which case Larry would be the plaintiff suing Tina. So don't get too confused. Either party could be a plaintiff or defendant. It is just sometimes the case that law professors will throw those little hints in there to orient you as to the identity of the various parties in the fact pattern. That concludes our Success Tips video on the topic of succeeding on essay exams. We hope this has been helpful. We wish you much success, and sincerely hope that this provides you with a very real legal studies advantage.